Tonight, court back in session with state troopers and a forensic scientist taking the stand.
I've never collected a sample from a red Solo cup before.
And ramping up discussion about Karen Reed's SUV.
You had no personal knowledge prior to your arrival of how long Michael Proctor had been with that SUV before you got there, correct?
That's right.
Details on the glass and hair found on the vehicle. We dive deeper with our legal experts on all that and more. Canton Confidential, the Karen Reed murder trial, starts right now.
Testimony was back in full swing today with a new round of witnesses taking the stand. Good evening. Thanks for joining us, everyone. Tonight, I'm J.C. Monahan.
And I'm Glenn Jones. Much of the testimony came from law enforcement, particularly Massachusetts State Police, including a forensic scientist from the crime lab. But the first witness to testify was John O'Keefe's niece. Cameras were shut off for her testimony since she's a minor.
John took custody of his sister's kids when both their parents died within months of each other. Melody Mendez joins us now live outside Norfolk Superior Court on what was a much busier day than the last few.
It really was, JC and Glenn, certainly after yesterday's unexpected last-minute cancellation. So let's start with John O'Keefe's niece, because during the first trial, you may remember that his niece and nephew both testified. Well, his nephew didn't take the stand today. This was just his niece. But she did give the jurors a glimpse into what she says life was like with John and Karen in the final months before his death.
John O'Keefe's niece described the deteriorating relationship between the couple, tension around the house, and an incident on family vacation in Aruba weeks prior. When John was upset about his nephew using an iPad on vacation, Karen defended him. At one point, she said Reed claimed John kissed someone else. Under cross, the defense established the relationship Karen had with the kids, where she took them to get haircuts, nails done, sporting events, and sleepovers at her house. Evan Brent, a Mass State Police trooper who worked with the Crime Scene Services Unit, took the stand. In a notable moment, Brent is the first trooper on the stand to acknowledge that Michael Proctor was the lead investigator in the case.
You knew at the time that Michael Proctor was the lead investigator on the case, correct?
Yes, I did.
More than half of the day's testimony was from Maureen Hartnett, a crime scene tech from the State Police Lab. She showed the jury photos of the damage to Reed's SUV. In cross, attorney Bob Alessi pointed out she had no way of knowing when that damage happened. The defense also noting that Hartnett tested the undercarriage of the vehicle and no blood was detected. And then the return of the red Solo cups. Alessi asked Hartnett if she'd ever seen anything like it.
Did you ever have to take swabs of red stained material from Solo cups that people usually use for other purposes?
I've never performed a collection like that, no.
As we learned last week, police in this case used Solo cups and a paper grocery bag to collect evidence from the scene. The focus then shifted to the tiny pieces of evidence and apparent hair and shards of glass collected from Reed's rear bumper after the vehicle was towed more than 30 miles from Dighton to Canton in blizzard conditions.
The glass pieces that were just perched on the bumper would have traveled about 60 miles before you saw them?
Is that what you're saying?
No. I don't know when the apparent glass appeared on the bumper.
Is it possible for glass that is perched on a bumper to travel 60 miles and be subject to average wind speeds of 15.7 and still remain on the bumper?
Alessi making sure to note the evidence was not affixed to the bumper in any way. The glass.
How hard or easy was it for you to remove those pieces of glass with tweezers?
It was not difficult.
Or the apparent hair.
It was easy. Again, I picked it up with a pair of tweezers.
Now, Hartnett will be back on the stand first thing tomorrow morning. Glenn, JC, we, of course, will be here for it all.
Melody, when it comes to the Solo cups, Robert Alessi asked Maureen Hartnett from the State Police Crime Lab whether any DNA testing was done on the swabs of those red-brown stains from one of the cups. But that's not part of her job, right?
Right. And she, in fact, said that she didn't believe any testing was done on those swabs. In fact, to your point that it's not part of her job, she said she actually left the cup and its contents at the Canton Police Department. JC?
Melody Mendez at the courthouse, thank you. Joining us now is our chief legal analyst, Michael Coyne, and criminal defense attorney, Neil Fagel. Welcome to both of you. Let's talk more about what the Commonwealth did today with the presentation of this physical evidence. Of course, the defense wants the jury to believe that that evidence got there improperly. So, Neil, maybe starting with you, who leveraged the physical evidence better today, do you think, the defense or the Commonwealth?
Well, I think the defense did a good job at the outset when they tried to bring Michael Proctor as the head of this whole umbrella. But then I think the prosecution did a nice job and very systematically going through the collection of the evidence, that the collection was done in an appropriate manner in accordance with all the policies and procedures that are in place. So I think it was almost a jump ball, as they say.
I guess bottom line here, Michael, is that the defense wants the jury to start thinking about the possibility that the evidence got there some way other than a collision with John O'Keefe.
Yeah, no doubt. And they planted those seeds a long time ago, and we see it on the cross-examination of a lot of these witnesses. The vilification of Proctor as the boogeyman, that he somehow infected all of the evidence in this case. All of the officers' interactions that we saw today were with the principal investigator, Trooper Proctor. And the witnesses, I think, held their own today much better than we've seen in the past, acknowledging the things that are indefensible and saying, yes, he is, and this and that. And trying to still provide the Commonwealth's case in significant part. I think the forensic scientists, that's a solid evidence, and I think the jury will hear that if, in fact, they can dig deep into the science.
And there were quicker answers. The day moved on a lot faster. There were still a few sidebars that happened, and one in particular came when the defense brought up questions regarding Brian Tully. That's the former head of the state police unit investigating Karen Read. And that prompted this question from Michelle in Methuen. Why wasn't Attorney Yannetti not allowed to ask questions about Tully and then was told he couldn't have a sidebar at first? Now, before you guys answer, let's play a bit of that moment from court today so we can see what we're talking about.
And so you were there when Lieutenant Tully was removed as the supervisor of that unit, correct?
That's sustained, and folks should to disregard that.
Now, if I could request an instruction.
Jurors, pay no attention to that question or answer. That is not properly before you with this witness.
Is Lieutenant Tully still the supervisor of that unit?
Yes.
I'm going to see you at sidebar for just a minute.
Did Michael Proctor reveal to you that he and Kevin Albert had socialized together by drinking alcohol in their his cruiser?
Sustained, and jurors, I'm going to ask you to strike that question. Disregard.
I need to be heard at sidebar.
Okay, so our viewer, Michelle, wants to know what was up with all of that. Let's start with you.
My guess is and correct me if you think I'm wrong, is that
I will.
Is that probably they had addressed this situation earlier in a motion in limine, and the judge had already made a ruling, and that the defense now was crossing that line. They knew they shouldn't have gone there. The judge already ruled that that was inadmissible and inappropriate to delve into that line of questioning.
Yeah, in fact, it's the motion you sent me last week that Attorney Brennan filed saying you don't really get in Massachusetts to challenge the quality of the investigation unless you have more evidence to support it. Because for the jury to even hear questions like that, you've got to have a sufficient basis that makes those questions relevant. And after the voir dire last week, the judge said, no, we're not going to hear any of that. And what they keep doing is pushing that door open, and they're trying the patience of the court. That's why they're not getting the sidebar.
But why not admonish them? They can keep doing this because, as we've talked about it before, once the genie's out of the bottle, you can't put it back in. He laid the foundation. Maybe that was planted and those people were fired.
All you have to do is ask the question to start planting those seeds. And so they know that they're trying the patience of the court, but they've got a defendant to represent, so they are going to push the boundaries of that order and hope that maybe she'll change their mind, or maybe some of these questions will be more permissible than what her prior ruling was.
All right, let's get back to some more of the physical evidence, because so much of the testimony today was about Karen Read's car. Of course, the Commonwealth is arguing her Lexus SUV is the murder weapon in this case, and most of the questions surrounding cross-examination focused on how the evidence, like bits of glass or hair, ended up on the back of the vehicle, despite 60 miles of travel back and forth from Canton to Dighton, et cetera, in the middle of a snowstorm for some of it. So I guess, is it plausible to raise these questions about how these little pieces of evidence remained affixed to the bumper?
Michael and I talked about this earlier. Since trials are now on TV and all over the social media, I liken this to the Mark Furman defense, where you have from the O.J. Simpson trial, where you have to try to start taking the case down from the top. And if the evidence that's coming in is not good because of some specific reason, then the jury should not consider it. And I think that's where they're going with this.
And I agree. The point you're making, though, and this is where common sense comes in, you say, 70 miles, round trip, snowstorm, one little piece of hair stays
You're
on
thinking
there.
how?
Exactly, and the little piece of glass. It doesn't take a scientist like JC to be able to say that this storm is going to cause all sorts of problems here. How do those things stay on that bumper throughout this? And I do think the jury looks at it in a common sense fashion, not necessarily science, and questions whether that, in fact, happened.
Yeah, you're covering a little bit of what I wanted to ask you. We're going to talk about the hair. Let's show the photos. The crime lab expert on the stand says she was able to remove it easily with tweezers, giving the defense that opportunity to question how it could still be there after the car was exposed to the storm. Well, she's not an expert on that, but again, they start laying that foundation. So what did you think about the moment when she said, no, I just took tweezers?
Another situation in this trial where something comes up like that, it doesn't seem plausible or credible that a small piece of hair would have stayed on the vehicle if it went all the way from Canton to Dighton and then Dighton back to Canton. But I think she did a good job saying, listen, my job was just there to collect the evidence. I collected the evidence in the appropriate way. It was documented by a picture. And then I submitted it to be analyzed. And we haven't seen what the analyzation is yet.
Well, hang on. So, Michael, if it's plausible that a layman would question how this could happen, is it a straight line from there to, well, a police officer must have done it?
It's not that crooked of a line, and it's not that big of a jump to make that. And that's what they're asking the jury to buy in by asking the question. I thought it was a great question for the defense, because if I can remove it with the tweezer, what I might take a splinter out of it or any other simple task, how did it survive such a challenge? And again, remember, the defense only has to create that reasonable doubt in order to get not guilty verdicts on these charges. And all of these things do, to an extent, chip away at the Commonwealth's case.
We're running out of time, so I'm going to give you one word. Who got more out of today, the defense or the prosecution?
You go first.
I'm going to go with the defense.
I'm going to go with the defense as well, because I think they, as Mike said, they put enough certain things in there to probably try to establish reasonable doubt.
With the exception of the niece. We didn't hear the niece's testimony. I think that humanizes John. So that you'd have to see that testimony in its entirety to make a final decision.
You're teeing us right up, because that is exactly what we're going to talk about when we go back. So don't go anywhere, because our courtroom insider Sue O'Connell will be joining the conversation. She was in the room when John O'Keefe's niece took the stand. So up next, we will go over her testimony. And of course, we'll continue to answer your viewer questions.
And before we go to break, we want to take a moment to remember John O'Keefe, the victim in this case. The Braintree native was a Boston police officer who became the legal guardian of his niece and nephew after the children lost both of their parents to illness. You're watching Canton Confidential, the Karen Reed murder trial.
Don't miss any of the Karen Reed murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
Back with us now is our chief legal analyst, Michael Coyne, and our courtroom insider, Sue O'Connell. And as we just heard at the start, today was John's niece who took the stand. Now, she's a minor, so there was no audio, no visual recordings allowed. Sue, you were in court. You were there to hear what she had to say without getting specific to protect what she has as a kid, and still had to say, what was the overall message that she got across to the jury?
Well, if you watched the trial last time, it was very much on point, almost exactly what she testified in the first trial. She's very articulate. She's very smart. She's very mature. She's a year older now than she was then, older than she was when her beloved Uncle John died. But she was basically able to set her relationship with John. They didn't spend as much time on it as I thought that they might, to humanize John some more. But she did talk about the relationship that John and Karen had, that in the end of the year and in January, it was deteriorating. They were fighting more. But again, also establishing that Karen took her to get her nails done once a month, took her to her own hairstylist, ironed her hair once a week so that she could go to school with straight hair. She and her brother sometimes slept at Karen's house. And also, it didn't come out immediately, but when that call was made to Jen McCabe that morning, she did say, maybe he was hit by a plow, maybe I hit him. But all in all, it was a bit of a wash, I think, in terms of, she had the relationship with Karen. It was a family relationship. They talked about Aruba, just to give that some context, if that's going to come up later in the trial. But, again, it was something that I think both sides could take something away from, but did it actually humanize what the relationship was and how they lived together.
So, Michael, we have the download now from Sue because, of course, we weren't able to see the testimony. There was a cross-examination this time around, different from the last trial. Based on what you've heard, was the cross-examination handled with the sensitivity it needed to be handled with?
From what's reported, I believe the answer is yes. I would have expected, as Sue said, that the direct would have humanized John more. And what the defense didn't really need to do, I think, and they didn't do it, is the fact is all relationships and all houses with teenagers in them are not smooth sailing.
Nope.
So their relationship had some bumps. I don't think it particularly helped the government. I think the part is, though, they can put a face to John, they can put some sensitivity to that and recognize what he lost. And so that's the advantage for the prosecution. She
got a laugh, though, when she got a little tangled up on the New Year's Eve, the timeline, and, and Yannetti wasn't pushing hard, and it was clear we had already established that. And she said something like, well, I had just broken up with my 8th grade boyfriend, so I was in crisis. I can't really remember here. So people got a laugh out of that. So it was a very human experience.
Yeah.
All right, let's take a look at some viewer questions, starting with Michael from Melrose. He wants to know, can Karen Reid's daily statements outside the courthouse be used by the prosecution? We know Karen Reid has spoken frequently outside of court since the trial began. Take a look at some of the compilations of what she said to reporters recently.
Inconsistencies, every statement's different. Under oath, not under oath, with the cops are all wrong. This is very similar to what we saw a year ago.
Do you think that she colluded with why is she so inconsistent?
Because she's lying. I saw John go in the house.
Can you describe him going to the house? Which door and how and when?
No, I have, though, and I'm sure the prosecution will play it.
Do you think Proctor will testify, Karen?
I don't believe so, but you've seen this afternoon how much evidence has not been shown to this jury. And we've had to work really hard, Alan's had to work really hard to organize it so that they can be presented with the actual evidence in this case.
So Reid's lawyers are under a gag order. She's her own spokesperson when she leaves court. Is she doing herself a service or a disservice?
I don't think she's done herself a service when she's talked to any of the media throughout the last couple of years. These statements would be admissible if the prosecution decided they wanted to offer them. They're considered admissions in Massachusetts. You can offer a party statement. Those statements we just saw wouldn't be particularly relevant. They would actually tend to support her case, so the prosecution likely wouldn't want to offer those. But as we've seen throughout, they've offered a number of her statements, including statements today about the relationship with Higgins and how that wouldn't have affected John.
Let's get to another viewer question. This is from Wanda in Falmouth, Maine. Hello, Maine. She asks, quote, I was recently on a jury in another state and as a juror was not allowed to take any notes during the trial. I've heard mention of jurors taking notes during the proceedings. Why is this allowed?
It's up to the judge's discretion as to whether the jury can take notes and in what fashion they can take notes.
Is that just here, or is that?
No, that's virtually everywhere. And some judges will even allow jurors to submit questions to the court that the court will then decide whether they will ask them of witnesses. We haven't done that here.
And they have to leave their notebooks there. Even when they go to lunch, they leave their notebooks on the table, on the chair rather, so they're not taking them with them or comparing notes. So I don't know how anyone could get through any trial without taking taking notes.
Seriously.
It's astonishing to me that some judges wouldn't allow it.
And you said this jury is more ferocious at that than the other.
I feel like I'm in class. I swear to God, I'm not being funny. There are 18 jurors, 5 continuous note takers. As soon as they get in, they take the notes, they refer to other things. Everybody on this jury has taken notes. And I think it's spread a little bit, except for one guy that, he's not taking that many notes. But we'll see if he makes it to the final.
What happens to the notebooks at the end of a trial?
They're custody of the Commonwealth. They are not going home with them to write their bestseller.
So don't write any love letters in there, or confess any crime while you're sitting in the jury box.
Maybe there's some doodling.
There could be.
I'm sure there are.
Doodling, yes.
That's what I mean.
Especially someone who doesn't want to take notes and feels the peer pressure.
Michael, Sue, as always, thank you.
And if you have questions about this case, keep sending them our way. The email address is on your screen, canton.confidential@nbcuni.com. We'll answer as many questions as we can.
And remember to join us every weeknight at 7 on NBC 10 Boston. We'll have a full recap of the latest developments from court, as well as legal analysis. Plus, this week's episodes will be streaming on Peacock starting Sunday. You're watching Canton Confidential, the Karen Reed murder trial.
Watch Priscilla Casper and Colton Bradford, weeknights at 6 on NBC 10 Boston.